Hi, this is James Ferrell with the Ferrell Maritime and Mesothelioma Law Group. I'd like to talk to you today about a frequently asked question as to whether there's a workers' compensation policy or workers' compensation insurance available to maritime workers. And that depends on what type of maritime worker you are. I've done a separate video on Jones Act seamen, but if you're a Jones Act seaman, there is no workers' compensation for Jones Act seamen. However, if you are working under the Longshore and Harbor Workers Compensation Act, there will be workers' compensation for you. So there's a difference. The Jones Act seaman is normally working in the service of a vessel. And what that means is that they're spending more than 30% of their time on a vessel which is in navigation. And in that situation, they will not be entitled to file a claim under the Longshore Harbor Workers Act. They will be able, however, to potentially get compensation through the Jones Act. Now, the Longshore Harbor Workers Act is a federal workers' comp plan, and it's administered locally through administrative judges. Under the Jones Act, you may, if you meet seaman status, and you're on your vessel more than 30%, and the vessel is in navigation, in which that simply means it's on navigable waters. The navigable waters can be an ocean, it can be an inland marine, it can be canals, it can be a river. Then more than likely, you're going to be held to be a Jones Act seaman. If you're found to be a Jones Act seaman, you have a claim against your employer, and it's called a non-delegable duty, meaning your employer, and only your employer, owes you the right to a safe working environment. You can have a claim for negligence under the Jones Act, and it only requires the slightest negligence on behalf of the employer. But some of the things that negligence means the employer did something wrong. They did not provide you with a safe working environment. And that can be anything from lack of training of the crew to not having sufficient amount of crew members, maintenance on the vessel, not providing the correct equipment, or not providing the correct safety equipment. Now, in addition to a negligence aspect, and now again, the employer only has to be 1% negligence. It's called slight negligence. So the law protects seamen, and if there is a call between the employer and the employee gets the benefit of the doubt. Now, an employer must also provide a safe vessel or ship for the employee to work around or on. This is called seaworthiness. So under the seaworthiness, it doesn't mean simply the vessel can go to sea. The vessel has to be reasonably safe for the seaman to work on. And some of the duties that could be violated by an employer in terms of an unsafe vessel are very similar to claims under the Jones Act. In some cases, the equipment will not be working. They will not have the proper equipment. In some cases, crew members will not be trained appropriately, or there will not be sufficient crew. So this is another avenue outside the Longshore Harbor Workers Act that would allow seamen to recover. So if you are injured on a vessel and you believe you have a claim, it's important to consult an experienced maritime lawyer to see whether you might qualify under the Longshore Harbor Workers Act, or you may be a seaman and have a Jones Act and seaworthiness claim. This is James Ferrell with the Maritime Mesothelioma Law Group.